Well, good evening. Thank you very much indeed for joining us for this 2023 Seabrook Chambers Public Lecture. My name's Matthew Harding and I'm the Dean of the Law School here at the University of Melbourne. Can I begin by acknowledging country? This evening we're meeting on the traditional lands of the Wurundjeri people of the Kulin Nation. I want to pay my respects to their elders, past, present and emerging. Just so you know, this evening's lecture is being recorded and the recording will be made available at our website soon. Tonight's lecture is part of an annual lecture series, the Seabrook Chambers Lecture Series. This lecture series was established some years ago by former judges of the Accident Compensation Tribunal in Victoria. The judges founded the lecture with the aim of enabling a lecturer of international repute to speak at the Melbourne Law School on a topic connected with the rule of law. And of course, this evening, we're delighted to welcome the Honourable Robert Redlich, AM KC, as our speaker. Also joining us tonight is Professor Kristen Rundle, sitting in the front. Kristen's a former co-director of our Centre for Comparative Constitutional Studies, and she's a world-renowned researcher working at the intersection of public law, I would say all law actually, but principally public law and legal theory. Kristen's going to offer some closing thoughts at the conclusion of the lecture this evening. Thanks for coming, Kristen. I'll just introduce our illustrious speaker and then I'll hand over to him. The Honourable Robert Redlich is well known to many of you already. His contributions to public life in our country are numerous. Of late, he's best known, of course, for his exceptional, one might also say gruelling work as the Commissioner of the Independent Broad-Based Anti-Corruption Commission, IBAC. Before taking up that commission, Robert was a long-serving judge of the Victorian Court of Appeal and before that a trial judge of the Supreme Court of Victoria. He's a past president of the Victorian Bar and in 2020 he was received as a member of the Order of Australia. Most importantly though, he's an alumnus of our law school. Given Robert's work on IBAC, he is eminently suited to addressing us tonight on the topic of the changing form of the executive branch of government and declining accountability. Robert, thank you so much for being with us this evening and I welcome you now to the lectern to deliver the 2023 Seabrook Chambers Public Lecture. Thank you.
Thanks, Matthew. Good evening, everyone. Over the past 4 decades, there's been a profound change in the way executive government operates. Those changes have brought with them a redistribution of power between government leaders, ministers, their advisors and public servants. Those changes have been the subject of frequent commentary by Royal and Integrity Commissions and other eminent sources, including the former ICAC Chief Commissioner, Peter Hall, that I'm delighted to see present today. Government leaders now have centralised control over the deliberations of the executive. The authority of ministers for their portfolio area has correspondingly decreased. Ministerial advisors' sphere of influence has greatly expanded, while the public service has been further marginalised and struggles to provide impartial, frank advice. The matters I'll explore this evening show that this shift in power has been accompanied by an increasing disregard for transparency and accountability. That permits codes of conduct, conventions, prescribed processes that are designed to prevent an abuse of power being bypassed with impunity. The environment encourages political expediency to override the public interest. Turning first to the centralisation of power around the leader of the government, the concentration of power is now an entrenched feature of the executive government landscape. This tight control challenges the independence and integrity of each of the other branches of government. Former Prime Minister Turnbull, in his evidence in the Robo-Debt Royal Commission, explicitly acknowledged the centralisation of power around the Prime Minister. Turnbull probably had in mind John Howard's consolidation of power as leader through reduced levels of ministerial responsibility, tight and secretive cabinets, and political control over policy and its implementation through an extensive deployment of his ministerial staff. A prime example of that concentration of power is former Prime Minister Morrison's secretly swearing himself into 5 ministerial portfolios. As the Solicitor General advised the government, this conduct subverted the fundamentals of responsible government and ministerial accountability. The consequences of centralised control can be seen in IBAC's Daintree report, which illustrates how the authority of the Premier's private office was able to influence the deliberative processes of the other elements of the executive. Both former health ministers in Daintree testified as to the concentration of power around the Premier. Turning to ministerial advisors, they are now recognised as a part of executive government. Their primary purpose is to support the minister to achieve the government's political objectives. There has been a consistent expression of concern for decades over the danger their role presents to integrity in government, with their ever-increasing ability to intervene in departmental process. In Victoria, they are employed by the Premier, and their numbers have continued to grow at an alarming rate. In the comedy series, Yes, Minister, the humorous script shows Sir Humphrey Appleby, the Secretary of the Department, secretly providing the Minister with this advice: Minister, the object of clarification is not to clarify things, it is to put oneself in the clear. But it's now the Minister's advisors who have the function of providing that political protection. They are described in reviews as a black hole of accountability, through which they provide plausible deniability to ministers, while insisting that public servants give effect to the wishes of the minister. The 2018 Thodey review of the Australian Public Service expressed integrity concerns arising from the gatekeeper role the advisor plays. Only 3 weeks ago, the Australian-New Zealand School of Government released research providing further confirmation that the advisor's gatekeeper function has become more pronounced as they obstruct the free flow of frank and fearless advice to ministers. IBAC's Daintree report contains adverse findings about the way the health ministers and the Premier's advisors conducted themselves, although that conduct was not found to be criminal conduct. The Daintree story commences with the Union Secretary's privileged access to the Premier's senior advisor, responsible for union affairs, and her access to the Health Minister's advisor. The ministerial advisor played a pivotal role in the union obtaining a contract to train health workers. Expecting the contract would be approved by the department, the advisors then worked on a further proposal to be announced in a pre-election commitment by the Premier of a $2.2 million partnership with the union for training health workers. The privileged access by the Union Secretary in Daintree was extensive, but it was hidden from public gaze. It was a prime example of unregulated lobbying conduct. Victoria, unlike its eastern counterparts, places no obligations on ministers or advisors to maintain a record of their dealings. IBAC's recent reports recommend urgent reforms in this and other areas of lobbying. Daintree highlighted the probity risk, where a party who has a special relationship with the government of the day seeks a benefit from the government. These special connections give rise to conflicts of interest. Yet in their evidence in Daintree, the Premier, the Secretary of the Union and the Minister's advisor did not accept that the government had a conflict of interest arising from the affiliated union's request for this contract. The Commission found that a conflict of interest plainly existed and rejected their evidence in this regard. The Minister's advisor helped shape the union proposal for a contract with the department, and then the advisor submitted the union's unsolicited proposal for a contract to the department for its approval. From that time onward, the staff regarded the wishes of the minister and the government as clear. But it was apparent to the procurement staff that the entity the union had created for the contract did not have the necessary expertise and would not be able to meet procurement requirements. Whilst the procurement process was underway, the Premier's senior advisor and the Minister's advisor prepared a memorandum for the Premier containing an announcement of a pre-election commitment based upon a union partnership. The Premier testified that he had little or no recollection of the matters surrounding the pre-election commitment. The Commission was satisfied that the content of the proposed pre-election commitment had been brought to his attention. Significantly, the election commitment to this large project in partnership with the union was made before the department had completed its procurement process on the smaller contract. IBAC found that the ministerial advisor improperly influenced and undermined the procurement process to ensure that the benefit to the union was delivered. Minutes before the commencement of the caretaker period, a senior executive officer entered into the contract with the union without a competitive tender. This was a contract that the former minister and others acknowledged should never have been granted. It was a contract which the former minister said in evidence was designed to place money in the hands of the union. Neither the pilot contract or the pre-election commitment for a large partnership with the union served the public interest. Once the implementation of the contract was underway, a different advisor to the minister, placed under undue pressure by the Premier's advisor, then interfered in the department's management of the contract to support the union's role, it being evident that the union entity was not fit for purpose. What then of the redistribution of powers on a minister's authority and responsibility? Whilst recognising that the content of the Westminster Convention and practices are not unassailable and may require adjustment to meet contemporary circumstances, ministers remain accountable to the Premier, Cabinet and Members of Parliament for the discharge of their responsibility, which includes the exercise of powers by their advisors and departmental officers. The Robo-Debt Royal Commission dealt extensively with the failure of relevant ministers to discharge their responsibilities in relation to the debt recovery scheme. The Commissioner found that the former Prime Minister, then the Minister for Social Services, in breach of his ministerial responsibility for approving the scheme, failed to properly inform Cabinet about the content of the proposal or to ensure that the proposed scheme was lawful. The Commission found the Health Minister also failed to ensure that departmental officers lawfully exercised their powers of overpayment identification. And the Commission made a similar finding in relation to the new Minister for Social Services, who the Commission found could not rationally have been satisfied about the legality of the new policy. Now, these robo-debt ministers advanced the now common ministerial defence that their role was there to implement the decision of Cabinet as announced by government, and it was not for them to question that course. The Commission made clear that reliance on Cabinet solidarity does not prevent ministers from investigating the scheme's fundamental features. They failed to meet their responsibilities. The Coate inquiry into COVID-19 hotel quarantine in Victoria found there was a profound lack of ministerial knowledge and accountability by the ministers involved. Victorians should have been able to see with clarity how such a decision came about and that it addressed benefits and risks. The former Health Minister acknowledged responsibility for what occurred as it was within her area of administrative responsibility, but she had not been briefed by her department and was not involved in the catastrophic decision to engage private security guards. Equally disturbing was the board's finding that there was no transparent rationale for the decision. The board found these were all failings of responsible government and ministerial responsibility. The making of the decision by someone unknown and the failure to consult the responsible minister or keep her informed are disturbing examples of the consequences of the redistribution of power and influence within the executive. That inquiry also showed that the contracting out of government duties is now a problem on a large scale and has contributed to the loss of expertise and morale within the public service. Of the quarantine debacle, Professor Rundle of the Melbourne Law School wrote that the failure of the Westminster principles were the product of features of contracting out that operate to undermine the structure of our constitutional system. This and other recent examples of the increased use of consultants shows that the interface between contracting out services and the mechanisms of political accountability are badly in need of reform. In Daintree, both health ministers and the Premier fell back on plausible deniability, claiming a lack of knowledge of what their advisors or department were doing. The former health ministers readily acknowledged that their advisors were working in, quote, an authorising environment, end of quote. IBAC found that the Premier and ministers all provided authorising environments for their advisors. IBAC found that the reliance by the ministers on their chief of staff, advisors, or the advice given from the Premier's private office could not relieve them of their accountability to Parliament for their advisors and their department's conduct under the Westminster Convention and the Codes of Conduct. The real concern by both ministers in Daintree about the centralised control of the Premier's private office was proffered to explain why their knowledge and control over matters within their portfolio was so limited. Their concerns reflect the fact that change in the balance of power between leader and minister has brought with it a systemic tension between ministers' accountability to Parliament for the discharge of their responsibility and the leaders and their advisors' relative freedom to intrude into the minister's portfolio responsibilities, thereby controlling the flow of information and the deliberative process. In Daintree, IBAC found that the Premier and ministers remained accountable to Parliament for their staff's conduct and concluded that these were matters for Parliament to consider in order to determine any question of personal responsibility. Parliament has a constitutional role to secure executive accountability. It's a measure that protects the public from abuse of power. The assumption of underlying ministerial responsibility is that Parliament, by their own internal procedures and regulations, will follow a system which facilitates transparency and accountability for ministers' conduct. To assist Parliament in discharging this role, Daintree recommended that the new Parliamentary Integrity Committee and the Ethics Commissioner that Government had committed to establishing following the Operation Watts report on branch stacking could add strength to parliamentary accountability and provide guidance on the scope of the Westminster Convention. The Government now expects the Watts reforms to be implemented by June 2024, but it's reported that these new bodies will be prohibited from looking at matters that had occurred before they are established. None of IBAC's findings in Daintree regarding the ministerial failings or the Premier's accountability under the Convention were acknowledged by Government. It now seems highly unlikely that they'll be addressed by Parliament. Turning to the functions of the public service, who should play a critical role in ensuring that decision-making serves the public interest, the continuing redistribution of influence in the executive space has magnified the risk of the public service providing only politically palatable advice. The shift in the public service to high staff turnover and fixed contracts provides a very strong incentive to delivering what they think the minister wants in breach of their own ethical obligations. Professor Coldrake, in his recent review of the Queensland Public Service, spoke of the challenge for the public service that is entirely opposite to the Victorian setting, quote, that the price for frank and fearless advice could be too high, sometimes devastatingly so, and the rewards too low. Matters of recent currency show that at both state and federal levels, it is generally the senior executive officers who place pressure on their subordinates to bend their views to the will of the government and avoid subjecting policy proposals to proper evaluation. We cannot presently hold expectations that public servants, particularly those occupying executive roles, will meet the public service aspiration of providing independent, frank and fearless policy advice. In the report of the inquiry into the former Prime Minister's appointment of himself to 5 ministries, Justice Bell was critical of the role played by the Secretary of the Department of Prime Minister and Cabinet. The Secretary told the inquiry that he saw no sign of the Prime Minister seeking to become President. It was not for him, as the Department Secretary, to stop a legal decision being implemented. Justice Bell reported that the Secretary of the Department ought to have raised the propriety of the appointments and their intended secrecy with the Prime Minister. Justice Bell reported this failure raised issues about the effectiveness of the partnership between elected government and its senior officials, a matter which had previously been reported on in the Thodey Review of 2018. IBAC's Daintree also exposed the pressure placed on middle management public servants by more senior members to meet a government desire to satisfy the union's request. To meet that objective required manipulation of the procurement process. Daintree found that middle management public servants and their subordinates were required by the executive to abandon their genuine opinions about the union's lack of expertise. Under intolerable pressure from above, they amended their view and advanced a position which reflected the will of the senior executives, that no competitive process was required and that the department should be able to contract with the union. In evidence, some senior executive officers frankly acknowledged that, quote, an indefensible culture, end quote, existed that required middle management and more junior staff to abandon their own views and provide advice that accorded with the outcome of the executive officers that they required. The findings in Daintree are not of some bizarre and unique set of circumstances. They mirror so starkly the findings in the Robodebt Royal Commission and also reflect the broad common experience of interstate inquiries and commissions. The Robodebt Commission found that through the role played by the Minister's advisors, the staff of the department were well aware of how government and the Minister viewed the importance of the scheme. The Commission found there was intense pressure applied by senior management, which resulted in reports to the Minister which spoke only of the resounding success of the measures, while staff concerns with the problems of the system were never ever a part of the briefings of the Minister. By the time Cabinet had approved the debt recovery policy in Robodebt, the Department of Social Services already had advice that concluded that such a scheme was contrary to policy and unlawful, but it was concealed. A memorandum of a subordinate who set out that it was fraudulent to raise a debt where none existed remained hidden. The Commission report sets out a catalogue of advices and reports identifying the flaws and unlawfulness of the scheme, all of which were concealed. The Royal Commission recognised in the federal domain the culture of fear in passing on bad or unwelcome news to the senior executive or the Minister. This led the Commissioner to express reservations about the ability to strengthen the public service to ensure that something of the like of Robodebt could not occur again. Meanwhile, the Victorian Public Sector Commissioner in late 2021, responding to the critical findings and recommendations of the COVID-19 hotel inquiry, set out guidance for public servants about how to respond to ministerial requests with unwelcome advice. Motivated by a need to address the decline in standards, the guideline specifically notes that shielding the Minister from information and advice that they may not be comfortable hearing is inconsistent with the principle of frank and fearless advice. It should be now beyond controversy that both at a federal and state level there's a culture, particularly within the senior executive ranks, of an incentive to please ministers and government. Such concerns have led to a referral by the Victorian Legislative Council to the Ombudsman to inquire into the politicisation of the Victorian public service. In the present executive environment of little transparency and accountability, it therefore should be no surprise to anyone that power may be more freely exercised for political gain rather than to serve the public interest. The Robodebt report found that as the public servants felt obliged to generate the savings that would meet the government's budget expectations, the process of properly evaluating the scheme was not undertaken. The Commission heard evidence from public servants that they were driven by, quote, deliver at all costs approach, the need to get it done. This sort of mantra underlying a deliberative process brings to mind the observations of Sir Gerard Brennan when delivering the Accountability Roundtable Awards of 2013, who said that the cry, quote, whatever it takes, is not consistent with the performance of fiduciary duty. Daintree illustrates the particular increased integrity risks associated with making pre-election commitments in an environment where power is centralised and ministerial responsibility diminished. Slogans from government of, quote, getting the job done, or, quote, doing what matters, may conceal the fact that there has been inadequate assessment, consultation, or compliance with prescribed process before a pre-election commitment is made. The Commonwealth Games and the Victorian Big Build, Victorian Rail Loop pre-election commitments both raise concerns about the adequacy of the assessments undertaken and the lack of required consultation before the announcements were made. Reporting on the Rail Loop pre-election commitment, the Auditor-General, an independent officer of Parliament, reported that the government had failed to show how the project benefits outweighed the costs. The Age and the Grattan Institute have both reported that the pre-election announcement by the former Premier was made without consultation with any one of the government agencies that are responsible for transport in Victoria, nor, it appears, was Cabinet consulted. The Grattan Institute opined that the process was emblematic of a mentality of doing big things for political gain which outweigh public benefit. The inquiry into the withdrawal from the Commonwealth Games appears to raise similar issues. Only last Friday, the current federal inquiry into the Games received a submission from the Peak Sporting Association complaining that there had been no transparency in the deliberation process. In the federal sphere, political expediency has been permitted to override integrity standards in the car park and the sports rort, when ministers authorising public grants in support of vested or partisan interests in marginal electoral seats or in seats held by the ruling political party. In neither case was there any acknowledgement by the minister or the government that such political motives were improper. The former Prime Minister asserted there was no maladministration or breach of any standards. The Auditor-General subsequently recommended that the reasons for such decisions should be recorded in a manner which provides transparency and accountability. The New South Wales ICAC has found particular circumstances of pork barrelling constitute corruption. The Grattan Institute research in 2022 and a corruption perception poll conducted by the Australia Institute only last month shows that the public considers pork barrelling a serious breach of faith that is a form of corruption. Robo-debt and Daintree are stark illustrations of how the absence of accountability may result in the executive seeking to hide misconduct. The Commissioner in Robo-debt set out in great detail the public attempts of the respective federal ministers to conceal from the public any understanding of the impropriety of the scheme or their wrongdoing or that of their department. The work of an Integrity Commission is not immune from the effects of political expediency. They face the occupational hazard that tensions may arise with any government of the day when integrity failings are under consideration. The political lens struggles to accommodate any objective bipartisan view on issues of integrity. And what may be regarded as the most egregious failing to emerge from Operation Daintree is the lack of accountability dictated by political expediency following the tabling of the IBAC report. There was no acknowledgement by government of its failings or a will to address them. Instead, the former Premier's alarming assertion to Victorians was that there were no findings in Daintree and by implication, no wrongdoing that needed to be addressed. Regrettably, that claim has now been repeated by the present Premier. IBAC encountered similar issues in the way the government majority on the Parliamentary Integrity Oversight Committee acted. The issues have been well traversed in the public domain and I need not repeat them, but they do show how politics can intrude into areas of Parliament's integrity work where there must be no place for politics. The majority of the misconduct I've discussed tonight is grey corruption, not criminal conduct. The criminal law is not designed to operate as the means for regulating the ethical conduct of public officials, and the common law offence of misconduct in public office is difficult to prove. Those working in the executive space are subject to much broader standards than those that inform the criminal law. They have a fiduciary duty to the public, which they undertook to observe on taking public office. Lord Mansfield in King against Bembridge identified the source of that duty as the duty of the principle of public trust, which requires public power to be exercised in the interests of the public, not primarily in the interests of individuals or the parties to which they belong. As the Ombudsman and I stated in the branch stacking investigation in Operation Watts, no crime was committed, but the misconduct was designed to favour political interests which corrode decision-making in the public interest. As Daintree also showed, grey corruption has precisely the same deleterious effects on public good as does a crime, but it is far more prevalent. In order for IBAC to be effective in exposing misconduct that has been improperly motivated and does not serve the public interest, IBAC must have unfettered jurisdiction like the newly established national body and the New South Wales ICAC to investigate grey corruption which breaches that public trust and is so deleterious to the public good. IBAC's confined jurisdiction operates to shield members of the executive from investigation, and it diminishes the Parliament's capacity to oversight executive action, thereby offending the constitutional principle of accountability. The Daintree hearings should have also been conducted in public. The IBAC limitation that there be exceptional circumstances and that the conduct amount to serious corruption, which is defined as a crime, prevented any public hearings. A public hearing would have encouraged public discourse, would have generated a quite different government response, and more likely would have led to the adoption of the important reforms. I don't want to leave the impression, however, that the work of integrity commissions and other oversight bodies can alone bring about necessary change in culture within the arms of executive government. Commissions depend largely upon whistleblowers or forensic journalists to lift the lid on misconduct. That's a relative rarity. Commissions investigate only a very small portion of executive conduct that breaches the public trust. The promotion of political expediency at the expense of the public trust is, however, the consequences of the unarrested power transition and a weakened system of protection. Each of the characteristics of executive government contribute to that end. All branches of the executive are too disposed to satisfying the political objectives of the government of the day at the expense of public interest and with little fear of accountability. To arrest the decline in standards within executive government, cultural change must be driven from within. Notwithstanding the distinct roles of each branch of the executive, the culture of each must be shaped by the same fundamental principle that we, the people, have entrusted them, directly or indirectly, with powers to be exercised in the public interest on our behalf. A strong ethical culture depends upon acceptance in each arm of government that there can be no deviation from that positive value. The necessary relationship between leaders, ministers, their advisors and senior public servants must be the subject of a conceptual design resting upon their fiduciary duty and codes of conduct. The design, driven from the top, must also address the fundamentals of the Westminster Convention. It must make unmistakably clear that the authority of ministers for their portfolio area is clearly respected by leaders and advisors alike. It must make provision for appropriate regulation and accountability of advisors, and it must require each public servant, regardless of seniority, to remain true to their duty of providing fair, impartial and frank advice. These steps are critical if public confidence in the executive government is to be restored. Thank you very much.
Okay, well, thank you so much, Robert, for the lecture, and happily we've got a few minutes to take questions from the audience. So what I'll do is invite you, when you're called on, to take one of the microphones. There are some microphones circulating, and please introduce yourself before you ask your question, and please keep your question short. So this gentleman here has his hand up. We'll start here.
Thank you very much. Isn't there a cause-effect relationship between centralisation of power and the increasing polarisation in politics? But the question is, I suppose, which way does it go, cause-effect relationship?
So I didn't catch the end. Which way?
Which way does it go, the cause-effect relationship? Which is the cause and which is the effect?
Well, as I said at the end of my remarks, there needs to be a rigorous and unambiguous devotion to reasserting the fundamental principles in which we expect executive government to operate. And there is no present will to see that occur. Unfortunately, we often hear politicians say, the views of the public will next be demonstrated at the polling booth in the next election. And of course, the fundamental error in that proposition is that makes an assumption that the public knows. And of course, what I'm directing attention to is the fact that so little of it is really understood. And that's what governments of the day depend upon in refusing to be accountable.
Yes, thank you. Up the back there.
I wonder if you could clarify what is the conventional responsibility and authority of a minister. In particular, can a Prime Minister override the decision of a minister or vice versa? And this in relation to Morrison's adopting of these portfolios. Was he giving himself any power that he didn't already have?
I'm sorry, sorry? The last bit?
Was when Morrison took over these other portfolios, was he giving himself any power that he didn't already have? And you say that ministers are responsible to Parliament, and you mentioned, I think, that Parliament should be considered an apolitical institution. But if it's just a bunch of politicians, how does that happen?
Yes, I think I mentioned in my lecture that the argument of the former Prime Minister was that what he did was legal, but it didn't address the fact, well, two facts really. The first was that I think with one exception, none of the ministers were aware that he had assumed that additional responsibility. And second, the departments were not aware of it. And so that immediately raised, as the Solicitor General said in his advice to Parliament, that immediately raised the question of ministerial responsibility and government responsibility. You can't have a situation in which it's unknown that there are two different parties who are responsible for the same portfolio area. The department has to know who's responsible.
So at the back, yes, thanks, and then I've got you down here.
I have a question related to right to information. Many times when we seek information, they give defense like it is in national interest not to disclose particular information. So how to balance national security against public interest?
How to balance?
National security and public interest.
I fear that's a matter that's probably beyond my expertise. No doubt when it comes to national security issues, there are always going to have to be exceptions to the ordinary rules. I think someone that's more immersed in that area would be better equipped to answer that question.
There was a hand, yes, thanks, this gentleman at the end here.
Are you being too critical of the ministers involved in the robo-debt scheme? If public servants suppress information that the scheme was, or don't push it up the chain that the scheme was legally invalid or doubtful, then how can a day-to-day minister be in a position to, if they receive advice that says this is valid or don't receive advice that it's invalid, commission their own legal advice? They've got to be put on notice. They can't be on top of every legal quandary that a particular administrative scheme might throw up.
Well, the Royal Commissioner, in what I might say is a compelling report, particularly about the Minister's conduct, relied in part upon the principle that ministerial responsibility arises not only in relation to matters known by the minister, but also matters that the minister ought reasonably to know. So the Royal Commissioner made a number of findings about things that she thought would inevitably have been matters about which a minister should have inquired and which the ministers refrained from doing. But the Royal Commissioner also made findings about a number of the ministers and their exact knowledge about some aspects of the scheme and was very critical of the fact that their knowledge of those matters raised with them such doubts about the validity of the scheme, the legislative mandate that could support the scheme, that they should not have accepted simply that Cabinet had made a decision which they were obliged to follow.
Thanks. I think there was a question.
Hello. I understood you to say that the normal laws don't apply to the ministers, for example, criminal laws. Now, short of the public accountability, do you propose any laws to be applied to ministers?
I regret to say I think you may have misunderstood me. I hope I didn't say that. Of course, ministers, like any other member of the community, is obliged to honour the law. My point really about the law, criminal law, if that's what you're addressing, was the criminal law is not the appropriate yardstick for judging ministerial or other executive officer conduct. They have a much broader obligation. They have that fiduciary duty which relies upon the public trust principle. And so any public officer is acting contrary to the undertaking they made when they took office to honour the public trust, if they make decisions which they know or ought to know are not going to further the public interest but serve some other improper purpose. That applies to ministers, their advisors, the public service.
Thanks, Robert. I think there was a question just here. Yeah.
Yep, thank you. I was just wondering what your thoughts are about potentially revisiting executive remuneration and contracts, as it might be a contributing factor. And also, what would you say to people who work in the public service who might be witnessing great corruption but don't feel they're able to speak up or don't know what action they can take without being negatively impacting them?
Yes. Well, dealing with the last point first, that's a really valid concern, and much is being said in the recent year or two about the importance of enhancing protections for whistleblowers. But most of the integrity agencies have a very strong regime of confidentiality, which will ordinarily protect those who wish to make complaints, including public servants, from disclosure. We now have a Public Interest Disclosure Act. We have legislation which can effectively give people those sorts of protections. I'm sorry, the first part of your question?
I was just wondering about revisiting executive remuneration.
Yes. Well, driven by the limitations of time, I couldn't dwell on that subject. I mentioned it in passing, but it's a profound problem. I mean, we have become numbed to the concept that the government of the day, on arriving in government, removes senior people in executive positions if they perceive that those persons may have in the past acted in a way that was inconsistent with the objectives the new government wanted. The days where there was security of tenure, regrettably for executive officers at a senior level, is past. And that, of course, brings with it part of the fear that Professor Coldrake was talking about, the fear of speaking out and thus jeopardising one's employment. That can only change with a government driven by a leader and the ministers supporting the principles that makes clear to public servants that no one will ever be discriminated against because they speak critically, they speak openly about the problems that a particular policy might present. That really depends on rectifying the internal culture.
Thanks. Yes, Stella.
Thanks, Matt, for mentioning my identity. I am a public servant, so I just want to make clear I'm asking this question in my personal capacity and not making any public comment. I understand one of the observations from RoboDebt was that it can be tricky when the General Counsel reports to an executive rather than, say, the secretary of a department, because sometimes the same executive that the General Counsel reports to is also responsible for the clients. So I'm just wondering, do you think that maybe the General Counsel should actually report to the secretary or to the head of the department as one of these practical ways to make sure there's no discrimination?
Oh, well, I think you make a good point, if I may say so, that's another feature of the executive government landscape, particularly in the federal area, where General Counsel, which of course must be acting according to the highest principles, needs to conduct themselves so that they are simply respecting the views of those who are making fair comment, impartial comment about the validity of policy. Unfortunately, it's too often the case the General Counsel's conduct is motivated, as it is with others, by political expediency. It's not their role, but unfortunately there's an expectation that too often General Counsel would discharge that role of the political policeman.
Thanks, Robert. I think we might have time for one more.
To my mind, there's no shortage of mechanisms that should govern conduct, good conduct. Policies, procedures, advice from council, supervision, risk management functions, assurance, that sort of thing. Any number of mechanisms which these people ought to know about, so they ought to have known what good conduct represents. So to my mind, it's about personal integrity, what people will do when they know what the right thing is, but they choose not to. Some people under pressure will do the wrong thing. We can call them, say, good apples gone bad. But then there are other apples which were always bad. And I wonder where you see the apple basket. What proportion were always bad and what went bad?
I think I've said many times over the last 6 or 7 years that whilst one aspect of the work of an integrity agency is to weed out the bad apple, we're not generally, in the area of grey corruption that I've been focusing on today, talking about bad apples. People who obviously commit crimes, that do things for personal gain. And what we're talking about here is the corrosive effect of grey corruption, so much of the time influenced by a political agenda. And that political agenda dominates because all of the senior elements of the branches of the executive government encourage it. So that's where the culture has to change. Everyone within the arms of executive government has to know that they can speak openly and fearlessly about what the right outcome on an issue is without fear that it might contradict the political objectives of the government of the day. Now, that can only happen with intense cultural change. The Public Sector Commission has got a huge role to play here, but my sense at the moment is there is still an insufficient realisation about the extent to which the culture exists and how challenging the task is going to be to make it change.
So, Robert, thank you both for the lecture and for taking those questions, very wide-ranging Q&A. I'm going to hand over to Professor Kristen Rundle to make some closing remarks. The only thing I'll add is very striking to hear you speaking of government as owing a fiduciary duty to the public that's founded in public trust. And that idea, of course, was so lucidly explored in the work of the late, great Paul Finn.
Indeed, I'm glad you mentioned that.
Yeah, so thank you so much.
Indeed.
And I'm going to let Kristen take it from here.
Thank you, Matthew. As Matthew's mentioned, my name's Kristen Rundle. I'm a professor here at the law school. One of my recent and very welcome responsibilities has been to be Robert's professorial host during the time of his appointment with us at the moment as an honorary senior fellow. Robert and I have had many, many conversations over the last few years because we are fellow travellers in this common cause of attempting to illuminate as much as possible that we are dealing with a radically changed political and governmental landscape that simply does not align with the stories we tell ourselves about how our system is meant to work. And when faced with that dilemma, we have two options. We either let the tail wag the dog, we let the standards that are being set by the processes of conduct that we're seeing, we let those standards become the standards we accept, or we refuse that and insist on reasserting the standards of the system that we all have signed on to and we expect our political and governmental actors to sign on to as well. Because what I see so often, and I think what Robert's charted so eloquently and passionately this evening, is that so much of political and governmental conduct in our era is designed in the image of where the gaps are in our mechanisms of political and legal accountability. It's almost as if what is possible is pursued with a vigour irrespective of what is lost to us by doing activity that, so long as it's short of something criminal, seems to be permissible. And what follows, and Robert knows only too well from his work at IBAC, is something of a cat and mouse game, a catch me if you can type of game, in which too much is lost around the edges of those extremes of the picture. So what are we to do with this landscape. And I think that Robert has helped us tonight to see how multifaceted the problem is and therefore how multifaceted our means of addressing it need to be. We need, obviously, the kinds of issues that Robert's spoken to in the responses to Q&A this evening, particularly the last point about whistleblower protections. But we also need very good journalism. We need the work of civil society organisations such as those who are represented here tonight, the Accountability Roundtable, the Centre for Public Integrity, who tirelessly work on these issues and comment on them. We also need to show great respect and regard for the labours of our various commissions of inquiries, including standing commissions like anti-corruption commissions, but also ad hoc commissions like the Robo-Debt Royal Commission, who give recommendations and they make findings, but above all, they also tell us the stories about what's going on. And from a public point of view, it's those stories that we learn so much from. And in your exchange just then, Robert, with the questions around Robo-Debt and what we learned from that Royal Commission report, it really is a gripping report for how it shows the enabling environments that began to crystallise. It's not your simple cause and effect scenario where someone has the brown paper bag and gives it to someone and something happens. These are slow-moving, normalising, enabling environments in which great departures from how we are meant to run our systems of government in Australia are allowed to crystallise and become normalised over time. And I've read some of that report closely, and they are absolutely gripping stories of, hour by hour, day by day processes in which what is expected is chipped away. And then that is normalised and that is consolidated. So these corrosive enabling environments are part of the big problem we have to address, and that you have spoken about the important role of commissions and their reports in illuminating those issues and setting our path ahead. But there also has to be a role for places like this, education institutions. And that's another thing I want to thank Robert for, is his role in this first pilot iteration of a subject that I have commenced here at the law school called the Executive Branch Research Lab. Robert has had many long conversations with me in my devising of this course, and also generously and enthusiastically took the role of mentoring 3 of the student projects, to much acclaim and appreciation of the students involved, all of whom are here tonight to show their gratitude and respect to you, Robert. But I devised this subject because the executive is the largest and most amorphous and most unwieldy branch of our constitutional order. It's pretty much everything that the legislature and the judiciary is not. And we need to understand what it is, how it manifests and what it gets up to before we can address the sorts of problems that Robert's been delineating tonight. So my own contribution to this scene is in the spirit of the basic wisdom of education, that if you want to address a problem, you have to understand it first. You have to map what's going on. And that's what I hope I'll be able to continue to do with the brilliant students that I have in that environment. So thank you, Robert, for speaking so clearly and urgently to a critically important topic. Your words were full of the clarity of experience, but also the reflections of someone who's thought deeply about the things that you have witnessed in your own public roles. I think I speak for everyone here when I say that you could not have performed those public roles with greater dedication and outstanding leadership. Tonight's lecture is in the spirit of that, but also I want to give my vote of thanks, not just for the lecture, but for the very many ways in which you've served the public in these roles, including in your tireless efforts to simply illuminate what is going on. So we have a small gift by way of appreciation from all of us here. Oh, it's heavy. So it's a small gift to you, but also I'd like to thank everyone here for supporting Melbourne Law School's public events like this. And if you'll join with me in thanking Robert Redlich.
Am I allowed to take this, Bill?
Thank you.